Welcome to the Ansons Podcast, and today I am joined by Harry Marriott, who is a barrister from St Phillips Chambers.
Hi Martin, good to be here.
Welcome to the podcast. So, a simple question, but I'm not sure if I spend my life trying to explain this distinction. What do you do for a living? What is a barrister?
So I am a barrister, which is a type of legal representative. So a bit like you as a solicitor, but slightly more court-focused. Sadly, as you say, the lines are increasingly becoming blurred, aren't they? So more solicitors are doing court advocacy, more barristers are doing written work, and that traditional distinction of a barrister being a little bit more of a court advocate is perhaps not the one it was.
Yeah, I mean, I would say that, what I do say to my clients is that barristers their specialism, for want of a better word, is advocacy. Appearing in court, convincing judges. And I know that that's not all that you do. And a lot of the time, barristers are used as specialists to provide opinions and to draft some of the statements of cases in different court cases. The real point of distinction, I would say, is the advocacy. And that's formed probably most of your training.
Yeah, and I think it's got to be like that, hasn't it? Nobody becomes a barrister to be sat in an office somewhere. They become a barrister to go to court. And I think as much as that line is starting to be a little bit more just sort of, muddled, it very much is still the cornerstone, isn't it? Going to court, doing the advocacy and actually convincing judges of things. And
how much of the court work now is actually done on a Teams call versus actually physically appearing in the court itself?
So I would say it went through a real high point during COVID. Mm-hmm. Obviously, as soon as COVID hit in 2020, everything went online. And we seem to be seeing an increasing push actually now going back to being in person. So certain very short hearings might remain online, but actually the vast bulk of court work is in court. And I think the logic behind that is actually it leads to results. It's a silly thing to say, but you can't really do a trial that well where you can't see the whites of people's eyes and actually engage with them. But
if you're cross-examining someone, that's you must have had to do a little bit of that during COVID, but to do that, online, that can't work the same way, right?
I don't think it does, personally. It just leads to all manner of issues. To give an example, let me take you through this document. If you've got a bundle in front of you and you're in person, it's simple and it's straightforward.
Yeah.
If you're online and it's on a screen and people are sort of struggling to actually find it and scroll through the pages, it just loses all of the rhythm, all of the flow, and it doesn't quite work.
Yeah, face to face, sometimes you can they're turning the page with you. You can point to the paragraph that you want them to look at, right?
Or you can just turn a document round and say, is that the document that you're looking at? It's so much simpler if you're there in person.
Very difficult to have a sort of Perry Mason stroke Rumpole, depending on your vintage. In fact, both of those are like 1980s TV lawyers. Whatever the modern references, I don't know the names of the guys from Suits, whoever Harvey or whatever the other guy was called. Moment on a Teams, it's got to be very tricky.
I don't imagine much of my work has those big smoking gun moments anyway, but I think you're probably right, which is there isn't that same engagement between you and a witness that you would get in person that you would get online. It just doesn't quite work in the same way.
I saw there was that, it must have been during COVID, where there was the American equivalent of a barrister, trial attorney, I think they call him, and he somehow had managed to turn the cat Jimoji or whatever you call it on his foot, and so it was making his submissions, and his face basically turned into a kitty cat. Or,
Thankfully, I've managed to avoid that one so far, but you never know, do you?
Well, especially if you sometimes, I've found this, if you sort of you use your work Teams or your Zoom and then outside of work, you've got to be a bit careful when you switch it back on that it's got the background that you might be using to sort of take the mickey out of your friends isn't on a professional call too.
But I think it's really interesting of sort of broader trends in the legal industry as well, isn't it? It's everybody thought everything would be going remotely, everybody thought everything would be abstract, and actually that in-person thing still stands strong. For you, I imagine it's so much easier to meet a client in person for the first time rather than do it online.
Yeah, I definitely think the first meeting is something that I would try to do face-to-face. I spoke briefly to a client today, and it's quite a serious issue, and I'm going to go drive down to see them on Monday just for that exact for that exact reason. But it isn't, and it's not sort of to demonstrate that I've got a just personal touch. I just think that you've got to build trust and rapport, and especially as a lawyer, often these are sort of very serious issues for people, whether it's them personally or the business that they're involved in. And I think to try and do that it lacks something.
Yeah.
And I think if I'm ever taking, or the rules around that have changed a little bit, have they not? But like taking witness evidence, preparing witness statements, again, that's something that I far prefer to do face to face.
I think it's probably the same on the advocacy side. You don't want to be meeting the client for the first time ever at the biggest moment of their life, which is the hearing of their claim. It needs to have that sort of relationship between you already established, even if it's a 5-10 minute phone call. The
thing that I do where it has been an improvement is, and I spent chunks of my career going to directions hearings, which for the audience is in a court case, often the judge will effectively set out the rules and the timetable for the conduct of the case. And a lot of the time we will reach agreement, both parties will reach agreement as to what that is, but a hearing is scheduled to force almost you to reach agreement. And then the hearing becomes, because virtually everything is agreed, you're sometimes looking for something to fall out of. You did one for a couple of weeks ago. But I've travelled to London, for example, and sometimes you're required, as the solicitor on the case, in certain of the courts down there, you're required to attend, only to get a train to London, 15 minutes in front of the judge, train back, and the time cost and the cost of the train and everything was ridiculous for,
I think that's a really good point, which is I think on those simple administrative hearings, there has to be a role for technology in those, doesn't there? And fundamentally, if it can avoid clients incurring costs, that's only a good thing. Is there any value in sort of forcing everybody to travel halfway across the country for a 15-minute largely administrative hearing? Probably not. And as you say, if parties can agree, they should. And if you can avoid incurring those costs, the court should definitely facilitate that.
I was speaking I was at St Phillips Chambers, your chambers, recently for some people had taken SILT, which is when you become King's Counsel, which is like a quality mark, is it not? Barristers. And I was speaking to one of the criminal clerks there, and he was saying to me that it's really sort of where it's been really helpful. They have similar directions hearings at the criminal bar, and in the past, there's relatively limited monies, and perhaps no one's going to drive for solicitors or barristers in criminal cases, but I mean, it's been vastly underfunded, and the use of Teams technology and all of the sort of video conferencing has just meant that large parts of the case management there can now be conducted online, and it's sort of almost saved the whole system, really.
Yeah, and I think that's sort of that backlog, as you say. I mean, neither of us are particular criminal specialists, but that backlog is a universal problem, isn't it? And I think the courts that we deal with, if there's anything that they can do to try and facilitate cases being heard, technology is probably the obvious way of trying to move things through.
Well, I mean, it's funny you should say that, because we've been saying that on this podcast quite a bit. Lots of different areas of law. An easy example being sort of possession proceedings. It's all very well and good, court saying about Section 21 notices and abolishing no-fault evictions and all that sort of stuff. Once you've got a possession order, I mean, you getting the appointment with the bailiff to attend is at the moment sort of 3 or 4 months away, to the point whereby if a landlord, and I'm not saying that it shouldn't be hard, but if a landlord is serving a Section 21 notice on the 1st of January, I'd go so far as to say you'll be lucky to get that property back by the end of the year.
Yeah, I think that's probably a fair comment. I think it is. As you say, pet cases need to be heard properly and they need to be properly determined. But once they have been, there needs to be resolution. It can't simply be dragged on and on and on. There needs to be an outcome, doesn't there? And I think that's a really good point, which is it's a resources issue, isn't it, fundamentally? A process exists. We know what the process is. It just needs to be administered timely.